Following amendment, clerk will read the amendment.
Amendment by Anchia.
Chair recognizes Mr. Anchia.
Thank you. Thank you, Mr. Speaker and members. I'm offering this amendment because the bill as drafted lacks an adequate exception for women's health. The current language in the bill, members, allows an exception to the 20-week ban on abortions for a complication of the woman's medical condition so that the abortion is necessary to, quote, avert the woman's death or serious risk of substantial and irreversible physical impairment of a major bodily function other than a psychological condition. Members, my amendment changes the bill, and specifically this definition in the bill, in 4 places. On page 2, lines 3 and 4, on page 5, lines 6 through 8, on page 5, lines 18 through 19, and on page 5, lines 21 through 22. And the change contemplates the fact that there may be medical conditions as determined by a physician in his or her reasonable medical judgment which fall outside the narrow exception. And frankly, the exception as drafted is unnecessarily restrictive. And while you heard the dialogue earlier between Representatives Farrar and Representative Laubenberg discussing medical judgment, I think the bill is poorly drafted in this regard. It would be much simpler and much cleaner and avoid complication if we just allowed medical professionals who are caring for a woman to evaluate whether there's serious harm to that woman's health. It's that simple. These decisions, members, are not for us as legislators to make. These decisions are between a woman, her physician, and her God. Now, my amendment does not change the construct of this bill at 20 weeks. In fact, it preserves that. And I voted on a number of different occasions here today to preserve the portions of the bill that say no abortion at 20 weeks. But you heard my dialogue earlier with Representative Davis when we talked about the constitutionality of a bill like this. And it must balance the interests of the health of a woman. The way it is drafted currently, members, does not achieve that. The exception is entirely too restrictive. So what I'm submitting, members, is that we allow a doctor to exercise their medical judgment and determine whether or not there is a serious harm to the woman's health. Now we know, members, and you've heard articulated today on the floor, that we're talking about 1.3% of all abortions today, those that occur after 20 weeks. And we know that 95% of those abortions are in the case of serious harm to women. So what we're trying to do, again, members, is balance the interest, I think, and there's overwhelming support in this body to draw the line at 20 weeks. But at the same time, we need to balance, the state has an interest in the health of a woman. And I don't come to this lightly, members. I mean, in our family, we have had serious challenges with reproductive health. These issues, I don't come to this from a partisan perspective. I look at this very practically. Where a man and a woman in a loving relationship, in a marriage, have to make some very difficult decisions about the health of the spouse. When their loved one has to look at someone in the eye and say, you may have a serious medical condition for the rest of your life, and that is outside the bounds of what this bill asks for. And frankly, members, I don't think we should be making those decisions here on the House floor. It is families that need to be making these decisions. It is families in conjunction with their doctors that need to be making this decision. It's family in conjunction with doctors and their spiritual advisors who need to be making this decision. And it, frankly, members, it needs to be families, the woman, their doctor, and their God. And this bill goes too far. So what we're trying to do, members, is fix the language of the definition. Everyone can go home comfortably and say we drew the line at 20 weeks. But we did balance the interest of a woman in a constitutional fashion. And we did preserve the medical judgment of physicians. And members, I come to this discussion also as a representative who represents a number of different hospitals. In fact, if you look at the line between where the district that I represent and that Representative Johnson represents, it is the entirety of the Dallas Medical District. And there's tremendous medical science that goes on there. And there are people who are trained in diagnosing serious medical harm to women. And those are the experts, and we should be deferring to their judgment and not supplanting their judgment with ours, members. So I ask you to help fix this bill. I ask you to help fix this definition, which is altogether too restrictive. And lastly, members, we must recognize that the definition as stated today cannot and will not achieve what many of you in the gallery are here to see achieved. Because this bill, as written, can or will be held unconstitutional. It has been held unconstitutional in other jurisdictions. And if you are serious about drawing the line at 20 weeks, then you must fix this definition. So members, I ask you to vote with me on this amendment to fix this bill and fix the constitutionality of its drafting.
Madam Speaker,
Yes, for what
will
purpose?
the gentleman yield?
Will the gentleman yield?
I yield.
The gentleman yields.
Representative Anchia, I thank you for bringing this amendment. It touches upon some of my concerns that I laid out earlier, in that the exception is just too narrow. And I tried to make the point at that time that if the author would widen the definition of endangerment to a woman to include a woman's health, and actually you set the bar a bit higher than even the constitutional standard. Constitutional standard is just, and by the way, are you aware that this is 40 years of legal challenges, that just women's health, the inclusion of women's health has to be a part of legislation. You are aware of that?
Yeah, absolutely. In fact, in Planned Parenthood v. Casey, the court spells out very clearly what the standard is. And if you'll permit me, I'll just quote from that case. They say if the state is interested in protecting fetal life after viability, which I think is a laudable goal, it may go so far as to prescribe abortion during that period, except, and this is important, this is what we're talking about, this is the exception that we're talking about today, except when it is necessary to preserve the life or health, I'll underscore that, of the mother. And that is current federal law. That is current federal law. And you're correct in pointing out that I even raised the bar a little bit in my exception, because I say serious health consequences, right? So in fact, this is a slightly more conservative approach. But you are correct to point out that if we exclude the health of the mother, we run afoul of the holdings of the U.S. Supreme Court in these cases, in 40 years worth of case law.
And so if you're a proponent of this bill or a supporter of this bill, you would, I'd imagine, want language such as this so that the bill will pass constitutional muster, correct?
Well, I see a lot of people here dressed in blue, and I assume most of them are Democrats like I am. That's why I wore blue. But they're really concerned about this bill passing. They want this bill to pass, right? And what I'm letting them know that the way this bill is drafted is flawed. And this exception that is set out is so narrowly drafted that it will not survive constitutional muster. And frankly, it has not survived constitutional muster in a number of other court cases across the country.
Correct. Moving on to the actual women's health, Did you hear me earlier when I mentioned the example of a woman being diagnosed at stage 4 cancer in her pregnancy, where she's needed immediate treatment that could endanger her pregnancy? This amendment would address a situation such as that, correct?
Absolutely. Look, I'm not here to require a loving family to engage in a Solomonic decision between saving and preserving the health of a woman, a loved one, who's a woman, and at the same time a viable fetus. I don't think we should be in the business of calling balls and strikes on that. These decisions are difficult. They're harrowing. I've experienced reproductive health challenges in my family, and I know how difficult those things are. Nobody takes this stuff lightly. In fact, after 5 months, what we're talking about today, I bet you parents in loving families really want to have a child. And they've painted the room. They bought the crib. They're thinking of names. So what you're talking about is the most difficult decisions. That's why it only happens in 1.3% of all the cases.
Mr. Stevenson raises a point of order that the gentleman's time has expired. The point of order is well taken and sustained. Chair recognizes Representative Laubenberg to speak against the amendment.
Madam Chair, I move to table this amendment for the reasons that in the bill we have put the exceptions in there for the physical life to the mother, physical health to the mother, and for the severe fetal abnormalities. And we give the physician full authority and to his best medical judgment what is in the best interest for the woman to save her life.
Madam Speaker.
Yes, Mr. Anchia, for what purpose?
Will the gentlelady yield?
When I'm done, please.
Not at this time, Mr. Anchia.
Thank you, Madam Speaker.
So, when Representative Chia points out that this abortion decision should be between the woman, her physician, and her God, essentially you're saying that there should be no abortion law, that the state has no compelling interest. And again, I want to point out that the portion of this bill that we're talking about is dealing with a 5-month baby based on the pain that the baby will feel at 5 months having an abortion. Now I would yield.
Madam Speaker.
Yes, for what purpose?
Will the gentlelady yield?
Yes.
Will the gentlelady yield?
Yes.